Welcome back, everybody, for another deep dive.
Yes.
This time,
Yeah.
we're going to be looking at something pretty fascinating. At least, I think so.
Yeah.
We are going to be going to Brazil.
Brazil.
We're going to be looking at the Brazilian legal system,
That's right.
specifically their civil procedure code.
Uh-huh.
And we're doing this by looking at this document.
Right. Conhecimentos específicos, condecíficos, LAI 13105 CPC 2015.pdf.
It's a mouthful.
It is a mouthful, but from what I understand, this is like a guide or a commentary
Yeah.
on the actual legal text itself.
You got it.
So the 2015 Civil Procedure Code of Brazil, and we're going to try to unpack some of this for you guys today.
Absolutely.
And kind of like see what's interesting about it, see how it compares to maybe some other legal systems that people might be familiar with.
You know, I think a lot of people will be surprised by what they find in here.
Yeah.
It's very different from a lot of, like the common law systems that we see in a lot of other countries.
Mm-hmm.
Yeah, definitely. And that's kind of what we want to focus on in this deep dive is like those little differences, those little nuggets of things that make you go, that's interesting. I never thought about that.
Yeah.
So, one of the first things that really jumped out at me is this idea that in Brazilian courts, every single decision has to be explained in writing.
Oh, yeah. Yeah.
There's no like, because I said so, allowed from the judge.
Right.
So what's the thinking behind that?
Well, I mean, it's fascinating.
Yeah.
Article 11 of the code states that all judgments of the judiciary shall be public and all decisions shall be reasoned under penalty of nullity.
Under penalty of nullity, that's serious business.
It is serious business.
So it's not just like a suggestion. This is like a core principle.
Yeah, it's a fundamental principle
Of their system.
You got it.
Okay, so this isn't just about the final judgment either.
Oh, no.
Article 10 even emphasizes that even if something should automatically happen according to the law, the judge can't base their decision on it unless the parties have had a chance to weigh in.
Yeah, that's interesting too.
So like, even if it's like a technicality or something, if it wasn't specifically like argued or discussed,
right,
you can't just be like, oh, well, this law says this, so I'm going to decide this way.
Exactly. You can't surprise the parties.
Oh, interesting.
With a legal argument.
Wow. So it's about ensuring that everything's out in the open.
It is.
Everyone has a chance to participate throughout the entire process.
That's a great way to put it.
That's a pretty stark contrast, I feel like, to some other legal systems.
It is very different.
Where things can feel a little bit more opaque.
Yeah, behind closed doors.
Yeah.
A lot of, wheeling and dealing.
Exactly.
That happens that is prevented here in Brazil.
Interesting. Okay, so we've established that transparency is key.
Yes.
What else kind of caught your eye as you were going through this code?
Well, I mean, Article 75 is quite interesting.
Okay.
It lays out who can actually be involved in a lawsuit.
Yeah.
And it's a surprisingly diverse list.
Yeah.
We're talking individuals, couples, states, government bodies, even condominiums.
Condominiums can sue people?
Condominiums can sue people.
I did not know that.
And it goes even further than that.
Okay.
It acknowledges entities that might not have a clear legal status in other systems.
Like what?
For example, you have something called irregular societies.
Irregular societies.
What are those, Rit?
What are those?
Think of like informal business partnerships or community groups that haven't gone through the formal incorporation process,
Right.
but still function as a unit.
So they're like recognized as a legal entity.
Exactly.
Even if they're not like officially incorporated or whatever.
That's right.
Interesting. Okay, so it's like the legal system is recognizing the reality of how people actually organize themselves.
Yes.
Even if it's not perfectly neat and tidy.
That's a great way to put it.
I like that.
Yeah.
Okay. Now this next part is where things get a little spicy. Article 80 kind of outlines this concept of bad faith in litigation.
Oh, yeah.
So it's basically a laundry list of what not to do if you don't want to get in trouble with the court.
It's true, and it's very specific.
Yeah.
It lists all sorts of things like, you can't alter documents.
Right.
You can't, misrepresent facts.
Right.
All these things that are, common sense, but they actually spell them out.
Right.
In the code.
So you can't just hide behind loopholes and, make things difficult for your opponent.
Exactly.
I'm curious, what are the consequences if someone does try to pull that kind of stunt?
Well, Article 81 lays out the penalties.
Okay.
And let me tell you, they don't mess around.
Okay.
Judges can impose fines.
Mm-hmm.
They can order the bad faith litigant to pay damages to the other party.
Okay.
And they can make them cover the opponent's legal fees.
Wow.
So it's a triple whammy.
It's a triple whammy.
Yeah.
Wow, so there's some teeth to this.
There are.
Okay. No wonder People seem to be on their best behavior
Hopefully.
in Brazilian courts.
Yes.
So we've talked about who can sue and how not to behave in court.
Right.
What about the lawyers?
Right.
What's their role in all this?
Well, lawyers in Brazil have some interesting limitations on their power.
Okay.
Article 105, for instance, highlights that they need very specific permission from their clients to do things like confessing on their behalf
Right.
or settling a case.
Yeah. You don't want your lawyer just going off and doing whatever they want
Exactly.
without your consent.
You got it.
Okay. But don't feel too bad for the lawyers, though,
No.
because Article 107 gives them some pretty impressive access to case files,
Oh, yeah.
even if they aren't officially involved in a particular case.
That's right.
Wait, really?
Yes.
So any lawyer can just waltz into a courthouse and start reading up on other people's legal issues.
Of course there are limitations,
Yeah.
especially when it comes to sensitive cases involving confidentiality.
Right.
But overall, this open access promotes transparency and helps lawyers stay informed.
Yeah, I can see how that could be useful for, like, spotting conflicts of interest or just kind of knowing what's going on in the legal world.
Absolutely. And it can also help to ensure that the law is being applied consistently
Right.
across different cases.
It's like a built-in system of checks and balances.
That's a great way to put it.
Okay, so we've kind of covered the players and the rules of the game.
Right.
Let's move on to the referees, the judges.
Okay.
What stood out to you about how the Brazilian legal system approaches judicial impartiality?
Well, Articles 144 and 145 really caught my attention.
Oh.
They address the concepts of impediment and suspicion when it comes to judges presiding over cases.
Impediment and suspicion.
Yeah,
Those sound serious.
they are.
What's the difference?
Impediment is a clear-cut situation.
Okay.
A judge is legally barred from hearing a case if there's a direct conflict of interest,
Okay.
like a familial relationship.
Right. So no judging your cousin's lawsuit.
Exactly.
Got it. What about suspicion? What triggers that?
It's a bit more nuanced. Suspicion arises when there's a reasonable doubt about the judge's impartiality, even without a direct conflict.
Like what?
Maybe the judge owes money to one of the parties or their spouse works at the same law firm as the opposing counsel.
Okay.
The code lists quite a few scenarios.
So it's not just about actual bias.
No.
It's about avoiding even the appearance of bias.
Both got it.
Wow. They really are trying to ensure
Yes,
that the public trusts the judiciary.
that's the goal.
Now, Article 147 kind of adds another layer of complexity to this.
It does.
It talks about judges who aren't directly related but are close enough
Right.
that it could raise eyebrows.
Yeah, like close friends
Yeah.
or, business partner.
So even if the judge is, like, completely impartial in their mind,
Right.
they might have to recuse themselves
They might.
just to avoid that perception of impropriety.
Exactly.
That's impressive.
It is.
What about everyone else we see in a courtroom?
Okay.
Clerks, bailiffs, all those other folks?
Right. The support staff.
Do they have a specific role to play in the Brazilian legal system?
Absolutely. Article 149 outlines the roles of the Auxilia da Justiça.
Auxiliares da Justiça.
Yeah, that's all the people who assist the judge.
Okay.
We've got the usual suspects like clerks and bailiffs,
Right.
but it also mentions some more specialized roles like translators
Okay.
and, intriguingly, partitioners.
Partitioners.
I know. What are those?
I've never even heard of that.
I hadn't either until I read this code.
What do they do?
Essentially, a partitioner is appointed by the court to physically divide property in certain cases.
Oh, so they literally, like, carve things up.
They do.
Okay.
Like, let's say you have a family farm that needs to be divided among siblings, or a complex real estate holding that needs to be split following a divorce.
Okay.
The partitioner has to make sure everything is divided fairly and equitably.
So like a legal referee,
Exactly.
making sure everyone gets their fair share.
You got it.
Okay, so we got judges, we've got lawyers, we've got a whole team of support staff. What about the actual day-to-day procedures in a Brazilian courtroom? Anything unusual there?
Well, Article 214 starts off with a fun one.
Okay.
No working on holidays.
I can't say I blame them.
Unless there's an emergency, of course.
Right, of course there are always exceptions, but like in general, take your holidays.
Take your holidays.
But wouldn't that slow things down?
It can, but the code also emphasizes efficient case management.
Right, so they try to balance it out.
Thank you.
Speaking of efficiency, Article 229 outlines a rule about deadlines that I found interesting.
Okay.
If you have multiple defendants in a case who all have different lawyers,
Uh-huh.
get ready for double the deadlines.
Yeah.
Whoa!
Double the paperwork.
What's the reasoning behind that?
It's about fairness.
Okay.
Each party needs enough time to prepare their case,
Yeah.
even if they don't share legal representation.
That makes sense.
Yeah.
So even though it creates more work, it's like
It does.
the idea is that it's fair.
It is.
What about the initial steps in a lawsuit? How does someone actually get summoned to court in Brazil?
You can't just spring a lawsuit on someone in Brazil.
Okay.
They have to be formally summoned to court.
Yeah.
That's where they call the cite to sound, where the summons comes in.
A cite to sound.
Okay. Article 238 outlines various methods from registered mail to electronic notifications.
So it's very formal.
Very formal.
You can't just like text somebody
No.
and say you're being sued.
No, you have to do it properly.
What if you're trying to sue a company, though?
Okay.
Do you have to track down the CEO to serve them papers?
Not necessarily.
Okay.
Article 248 offers a surprisingly practical approach.
Okay.
Anyone with general management or administrative powers in a company.
Right.
Even the mailroom guy can legally accept a summons.
The mailroom guy.
Yeah.
Seriously?
Yeah.
That seems a little risky.
It does a little bit.
What if they just like forget to pass it along?
There's always that risk.
Yeah.
But, it prioritizes practicality and efficiency. And, the onus is on the company to have internal procedures in place.
Right, to deal with this.
Yeah.
So it's a system that kind of trusts but verifies.
I like that.
Speaking of things going wrong,
Okay.
what happens if the court itself messes up the procedure?
Well, Article 277 is reassuring in that sense.
Okay.
Even if the court makes a procedural error,
Uh-huh.
as long as the intent was clear, the act might still be valid.
So they're not going to like throw out the whole case
Right,
just
okay.
because somebody like dotted the wrong in or something.
Exactly. As long as it's clear what they were trying to do.
But what if things go really wrong?
Okay.
Like the entire case file disappears.
Okay.
Is there a procedure in place for that?
There is.
Okay.
It's outlined in Article 712.
Okay.
It's the process for restoring lost records.
Wow.
They'll gather whatever evidence they can find, copies of documents, witness testimonies, the judge's notes.
So it's like a whole big investigation.
It can be.
It seems like the Brazilian legal system really tries to cover all the bases.
They do. They really do.
It's very thorough.
Very thorough.
Okay, we're going to take a quick break,
All right.
and we will be right back to discuss even more
Sounds good.
of the Brazilian Civil Procedure Code.
More to come.
Stay with us.
Yes. Welcome back to our exploration of the Brazilian Civil Procedure Code.
Yeah, so last time we were talking about like how the system deals with procedural errors and even missing case files.
Right.
Like, it's kind of incredible how much thought has gone into making this system
It is.
thorough and fair.
They really try to cover all the bases.
And I have to admit, I'm also kind of wondering,
Yeah.
like, with all this detail, does it ever get to be too much?
It's a good question.
Like, how do people even navigate this?
Yeah.
This, like, intricate web of rules and procedures?
Well, I think that's where the structure of the code really comes in handy.
Okay.
It's organized in a way that aims to provide clarity amidst the complexity.
So it's not just like a giant jumbled mess.
No, it's very systematic.
Okay, good.
Very logical.
So let's talk about like the actual trials themselves.
Okay.
How do those actually unfold in Brazil?
All right.
Is it like all dramatic speeches and like tense courtroom battles?
Well, there's always a certain level of drama
Yeah,
in any legal proceeding,
right.
but the Brazilian system is known for its structured and organized approach.
So it's not quite like what we see in the movies.
No, not necessarily.
Okay, good. Because I was getting a little nervous.
Article 926, for example, highlights the importance of consistent and stable legal precedent.
So judges can't just like make rulings based on their gut feeling or
Right.
personal opinion.
They have to follow established legal principles and precedents.
That makes sense.
Yeah.
So if similar cases are treated similarly,
Right.
it creates a sense of like balance
Yes.
and trust in the legal process.
Exactly.
Are there like specific guidelines about how judges should approach those precedents?
Absolutely.
Okay.
Article 927 outlines a hierarchy of legal sources
I love a good hierarchy.
that judges must consider when making decisions.
So it's like a legal pyramid.
Yes. Think of it like a pyramid,
Okay.
with the most authoritative sources at the top, guiding all decisions made below.
So like what's at the very top of this pyramid?
At the very top, we have decisions made by the Supreme Federal Court,
Okay.
particularly those relating to constitutional matters.
So that's like the ultimate authority.
Exactly. Those are the guiding principles.
Okay.
Then we have binding precedents set by superior courts,
Okay.
rulings on recurring legal issues,
Okay.
and finally guidelines established by the specific court where a case is being heard.
So there's like a whole system in place
There is.
to make sure that the law is being applied consistently.
You got it.
It's not just one judge's interpretation.
No, it's a collective effort
Okay.
to ensure fairness and consistency.
Now, how does a case actually get assigned to a judge in the first place?
Good question.
Is there like a system to prevent, you know, any funny business?
Well, that's where Article 930 comes in.
Okay.
It talks about the distribution of cases within the court system and emphasizes transparency and fairness
Okay.
through random assignment and public access to information about case allocation.
So you can't like try to influence which judge gets which case?
No, not at all.
Okay, so it's random.
It's designed to be completely impartial.
Okay.
So each case should be judged on its merits,
Right.
not on who the judge is.
Or who they might be connected to.
Exactly.
Okay, that makes sense.
Yeah.
So once a case is assigned, what happens next?
Well, Article 931 outlines a clear timeline for the initial stages.
Okay.
The assigned judge, known as the relator,
The relator.
yes,
Okay.
has 30 days to review the case,
Okay.
prepare a report, and draft their initial opinion.
So there's like a whole behind-the-scenes process.
There is,
Okay.
before the case even gets to the courtroom.
So it's not just a matter of like showing up in court and presenting your case.
No, it's much more involved than that.
Okay.
They really take their time.
Now what about court hearings?
All right.
Is there anything specific about those in the code?
Yes. Article 934 focuses on scheduling and, importantly, making sure everyone involved is properly notified.
So no surprise court dates?
No. The court is required to publish the schedule of upcoming hearings, giving all parties involved ample time to prepare.
So everyone's on the same page.
Exactly.
That's good.
Yeah.
But what if like somebody needs to postpone
Oh, yeah.
their hearing?
Good question.
Can they just like call up the judge and be like,
Yo.
hey, can we reschedule?
It's a little more formal than that.
Okay.
Article 935 allows for some flexibility,
Okay.
but any changes or postponements have to be communicated publicly
Okay.
and with adequate notice to all parties.
So it's all very transparent
Very transparent.
and above board.
That's right.
Okay, I like it.
Yeah.
Okay, so we've got our case scheduled. The judge has reviewed it.
Right.
Now it's like showtime.
Okay.
What can we expect to see during a Brazilian court hearing?
Well, Article 937 outlines some key elements,
Okay.
emphasizing the right to oral arguments and the role of the judges in questioning witnesses.
So it's not just like lawyers reading from dry legal documents.
No, it's much more interactive than that.
Oh.
The judges play an active role,
Hey,
ensuring that all relevant arguments are heard.
it sounds much more lively than I initially imagined.
It can be.
Now, let's say the judge has heard all the arguments,
Right.
issued a ruling.
Uh-huh.
What if, like, something's not quite right with the decision?
Okay.
Maybe it's unclear or, like, the judge seems to have missed an important point.
That's where embargos de declaración, or motions for clarification, come into play.
Motions for clarification.
Yes.
Okay.
Article 222 outlines the situations where these motions can be filed.
So if there's, like, something ambiguous or contradictory
Right.
or even missing from the judge's decision,
Yeah.
you can essentially ask for a do-over.
Well, it's not quite a do-over,
Okay.
but it's a way to address any issues with the clarity or completeness of the ruling.
Okay, so it's like a legal proofreading process.
That's a good way to put it.
Okay.
Making sure everything is in order and everyone understands the judge's decision.
But it's not about, like, trying to get a different outcome.
No, it's about clarity.
It's about making sure everyone's on the same page.
You got it.
What if someone disagrees with the judge's decision, though?
Okay.
Is that the end of the road?
Not necessarily.
Okay.
The Brazilian legal system has a multi-layered appeals process.
Okay, so there's still hope.
There is.
What options are available for appealing a decision?
Well, Article 994 outlines the various types of appeals,
Okay.
each with its own purpose and procedure.
Okay.
There's apelação, which is used to challenge the overall decision of a lower court.
Right.
Then there's agravo de instrumento, which is more focused, challenging specific rulings or actions taken by the judge
Okay.
during the proceedings.
Okay.
And if different courts have issued conflicting rulings on the same legal issue,
Right.
there's embargos de divergência, which aims to unify the interpretation of the law.
Wow. So it's a pretty complex system.
It is.
But it seems like they've really thought of everything.
They've tried to.
It's not just one judge making the final call.
No.
It's like a whole system.
A system of checks and balances.
Yeah, to make sure that, the best possible outcome is reached.
That's right.
I can imagine this whole appeals process takes a lot of time, though.
It can.
Reviewing all that documentation, scheduling hearings,
Right.
letting everyone present their arguments.
It takes time.
But I guess the goal is to reach a just resolution.
That's the goal.
Not just like a fast one.
Exactly.
Sometimes taking the time to get things right is more important.
Absolutely.
Are there any other like unique features of the Brazilian legal system?
There are a couple of things that might surprise those familiar with other legal systems.
Okay, like what?
Well, Article 1026 reveals an interesting twist
Okay.
when it comes to embargos de declaração.
Those motions for clarification.
Yes.
Oh,
Unlike many other appeals,
mhm.
embargos de declaração don't automatically put the original ruling on hold.
Wait, so even though you're like asking the judge to clarify or correct their decision,
Uh-huh.
the original ruling is still like in effect?
In most cases, yes.
Wow, that's interesting.
It is.
It definitely puts some pressure on judges
It does.
to get it right the first time.
Yeah.
Anything else?
I think it's worth mentioning Article 535,
Okay.
which addresses how the government, or Fazenda Pública,
Fazenda Pública.
yes,
Okay.
as it's known in the code,
Okay.
participates in legal proceedings.
So the government has to like play by a slightly different set of rules.
It seems so.
Interesting.
Yeah, it outlines specific rules and timelines
Okay.
that apply solely to government entities.
So it's not about like giving them special treatment.
Yeah.
It's just about recognizing that they're different.
Right. They have a unique role
Okay.
within the legal system.
So the government's not just like another party in a lawsuit.
Exactly.
They represent a whole other set of interests
That's right. Okay.
and considerations.
That makes sense.
Yeah. It's fascinating how much thought has gone into creating this system
It is.
that's both comprehensive and flexible,
right.
addressing the needs of different players.
Yes, it's very impressive.
Okay, so we've covered trials, appeals,
Mm-hmm.
even the unique role of the government.
Right.
What's next on our legal adventure?
Well, next time we're going to dive into some of the more specialized types of lawsuits outlined in the code,
Okay.
from property disputes to the dissolution of partnerships.
I'm ready.
All
I
right.
can't wait.
Let's do it.
All right, so we're back, and we are finally ready to get into some of these
Yes.
specific, kind of unique lawsuits
Right.
that exist in Brazil, at least according to their civil procedure code.
Exactly.
Last time you were mentioning things like demanding someone to account for missing money
Yes.
and procedures for protecting possessory rights.
Right.
So, like, I'm eager to hear more about that.
All right. Well, let's start with ação de consignação em pagamento,
Ação de consignação em pagamento.
or action for payment deposit.
Action for payment deposit.
Yeah.
Okay.
Which is outlined in Article 542.
Okay, what does that mean?
So imagine you're trying to pay a debt,
Oh,
but the other party is either refusing to accept it or making it impossible for you to do so.
like they're just not taking your calls or something.
Exactly. Or they've moved
Right.
and they haven't given you a new address or whatever.
Okay.
So this action basically provides a legal framework
Okay.
for you to deposit the payment with the court.
So you're like, I'm trying to pay,
Exactly.
but you're not letting me.
You got it.
Okay.
So it protects both parties, really.
Okay.
The debtor is protected from accusations of non-payment,
Right.
and the creditor can't unfairly withhold acceptance of the payment.
So it's kind of like a safeguard
Yes.
to make sure that
Prevent misunderstanding.
everyone's acting in good faith.
Yeah.
Okay.
So it's a very useful action.
It sounds like it.
Yeah.
Now, let's talk about those possessory rights. Is it really possible to legally occupy a property you don't own in Brazil?
Well, it's a bit more nuanced than that.
Okay.
The ação possessoria, or possessory action outlined in Article 5554, isn't about endorsing squatting,
Okay.
but rather about protecting someone's right to undisturbed possession of a property,
All right.
even if they don't hold formal ownership.
So it's like addressing those gray areas where it's not totally clear
Yeah, you got it.
who owns what.
Exactly.
Okay.
And it's particularly relevant in a country like Brazil with its history of informal land settlements
Right.
and complex property disputes.
So if you've been living on a piece of land openly and peacefully for a certain period,
Mm-hmm.
you have some legal recourse.
You do.
If someone tries to just kick you out,
Yes.
even if you don't have a deed in hand,
It's right.
that's interesting.
It is.
What other unusual lawsuits have you uncovered?
Well, Articles 569 and 599 caught my eye.
Okay.
They deal with two very different
Okay.
but equally important situations: boundary disputes and the dissolution of partnerships.
So on the one hand, we have neighbors arguing over fences.
Right?
And on the other hand, we have business partners splitting up.
Exactly.
Those do sound very different.
They are, but they both involve the need for clear rules
Mm-hmm.
and procedures to ensure a fair outcome.
Right.
So Article 569 outlines the assume de demarcation and the assume de division.
Assume de demarcation and assume de division.
Right.
Okay.
Which address boundary disputes and property division, respectively.
So if your neighbor decides to build their fence,
Yeah,
like a couple feet onto your property,
exactly.
or you inherit a piece of land with your siblings and need to figure out
Right.
who gets what.
You got it.
Okay, so these are the actions
Those are the actions.
that would cover those scenarios.
Exactly. It's about clearly defining property lines and ensuring a fair division of assets.
Right, especially when things have the potential to get messy.
Absolutely.
Okay,
These are very emotional issues.
Yeah.
And, people can get very attached to their property.
yeah,
So it's important to have a clear legal framework
right.
in place to resolve these disputes.
So the code outlines a specific process
It does.
for how to handle these situations.
Yes. It talks about surveying, dividing, and even auctioning off properties if a fair division can't be reached.
So even if you can't agree,
Right.
the system steps in
The system steps in.
and figures it out.
That's right.
Okay, what about dissolving those business partnerships?
Right. Article 599 outlines a process for that.
Okay.
It provides a legal roadmap for untangling those relationships and dividing assets fairly.
I mean, dissolving a business partnership sounds like a nightmare.
It can be.
You've got shared assets, you've got debts.
Right.
Often you've got like hurt feelings
Exactly.
and conflicting opinions about what to do.
Yes. It's a very complex situation.
So this part of the code is like,
It provides a framework
okay,
for doing it in a way that's fair
Okay.
and legally sound.
so it's like a safety net. It is for businesses.
Yeah.
It seems like the Brazilian legal system really does have a procedure for just about everything.
They've tried to be very thorough.
It's pretty impressive.
It is.
Well, we've covered a lot of ground in this deep dive,
We have.
and I think it's time to start wrapping things up.
Okay.
As we've been discussing this whole Brazilian Civil Procedure Code,
Right.
it's a pretty complex document,
It is.
but it's also clear that a lot of thought has gone into creating it.
A lot of thought.
It's a system that's designed to be fair,
Yes.
transparent,
That's right.
and accessible.
Absolutely.
And it's really interesting to see how they've managed to balance
Right.
all of those different factors.
It's a delicate balance,
Yeah.
but they've done a pretty good job.
So I guess the takeaway for our listeners is
Yeah.
if you're ever in Brazil and you find yourself needing to navigate their legal system,
Right.
don't worry.
You're in good hands.
There's a process for everything.
There is.
Just make sure you've got a good lawyer
Good advice.
and you should be all right.
Absolutely.
Well, thanks for joining us on this deep dive.
My pleasure.
And we'll see you next time for another fascinating exploration
Looking forward to it.
of something new and different.
Absolutely.